formula. Please note this, my lord. This only Sardar could have spoken. And now, my lord, it has proved to be, my lord, prophetic. He said that after all, neither Sheikh Abdullah nor Gopala Swami was permanent. The future would depend on the strength and guts of the Indian government.
This is not a political.
And if we cannot have confidence in our strength, we do not deserve to exist as a nation.
If I may just seek the permission of the learned Solicitor General, we were all told on 3rd of July to file all documents.
Again,
there's nothing to be filed thereafter.
Continues it.
This is administered.
Mr. Sri Singh,
Who were given, all of who were given.
Mr. Singh, let him continue. I mean, what's
This side patient.
No, when your side argued, there was no interruption from either the attorney or the solicitor.
Lord, many of them provided additional documents,
But,
additional judgments. We never objected.
These are well established. These are well known.
Why such sensitivity over some statement which comes because may not be palatable?
Also, Mr. Singh, Mr. Singh, equally we know that when we decide the matter, we have to give primary importance to primary sources,
Yes.
such as the statutes, the instruments of accession. These are other documents which he is relying on. The extent
was dead. Nurani was not even born when all this happened.
It's extract put in a list of dates.
I did object to Nurani. It's a one-sided
No,
picture.
your nodal counsel argued that he received it Sunday evening.
I'm sorry.
Your nodal counsel, he agreed in the morning that he received it long back, but he did not circulate it amongst you.
On Sunday, last Sunday.
I'm saying that there are extracts from a book in a list of dates. The book is not on record. It's not a document before your lordship.
We'll give more copies of the book.
That's not the point. I mean, this can just keep getting enlarged. I'm only saying that let's stick to the record. We were
Lord, if
told-
AG Nurani can be read, even a newspaper can be read. I'm sorry, I'm saying this with seriousness. I have read AG Nurani. It is a one-sided. But we didn't object.
That's all right. Mr. Solicitor, you don't have to go that far.
No, my lord, I'm on page 40.
Mr. Singh, all that this really indicates, it's not like, conclusive evidentiary material.
Yes.
This is used to demonstrate that there were different points of view, different perspectives which were flowing in at that time.
A historical perspective of what people felt at that particular time.
There are several things mentioned by
dialogue that was
I would-
taking place, where one side was expressing one view, the other side was strongly opposed to it. Ultimately, we have to interpret the provision of the Constitution.
Exactly.
How this all came about,
This
that's
is
all
an
that we are
aid of
concerned.
Sibal, you also referred to certain
I
documents.
mind whether this going on, but I mean,
That's all right. These documents give us some
That's right.
air of the background,
I-
of different perspectives to the background.
Several new facts were stated. I didn't object because I didn't want to trivialize the dialogue. This is the constitution bench we are at.
Etc. Please proceed.
So kindly come to page 44.
If I not can be read in this.
Yes, sir. Lord, 43 bottom. In the course of discussions regarding federalism in India during the Constituent Assembly, Jaspat Roy Kapoor, representing United Provinces, commented, I only wish that Kashmir should also
So you are reading page? 44.
Page 43, last date, my lord. This is Constituent Assembly debates, CCD, my lord, document volume 8, PDF, my lord. I've quoted for your lordship's easy reference.
Just put the back.
In the course of discussion regarding federalism in India during the Constituent Assembly, Jaspat Roy Kapoor, representing United Provinces, commented, I only wish that Kashmir should also have been brought in on the same level as other states, but unfortunately, much to our dissatisfaction and chagrin, if I may say so, this would not be done. This is a delicate subject and I'll not say anything more on this. But please read this, my lord, now. This is very, very important, and in my respectful submission, the answer, my lord, lies here. What happened to Jammu and Kashmir, its sovereignty, external, internal, my lord, the difficulty is the petitioners are confusing, in my understanding, internal sovereignty with autonomy. external sovereignty, my lord, nobody can dispute that it is with the Union of India. Internal sovereignty in the facts of our case and in the constitutional structure which we have accepted would mean autonomy of the federating units. And which autonomy is there with every state? There are none.
It's actually there with every institution.
Every institution is autonomous. So that's not
I mean,
internal.
we have the autonomous authority to decide a constitutional issue.
Commission.
But we can't say that internal sovereignty rests with us. We are an independent autonomous institution under the
They are
Constitution.
confusing the word autonomy with internal sovereignty. There is no internal sovereignty.
Except that, Mr. Solicitor, to paraphrase their argument fairly, what they are saying that, look, we gave up external sovereignty, there's no doubt about it. They say that we have acceded to the Indian Union, that's irrevocable. But they said that the course of events, the adoption of 370, would indicate that while there was a giving up of external sovereignty, a modicum of internal sovereignty, which was exercised by the then Maharaja, that was not ceded to the Indian Union. That seems to be the line of.
That's the submission, Madam. And my respectful.
And therefore, they are relying on various judgments of our court to indicate Indira Nehru Gandhi versus Rajnayan, to indicate that sovereignty has an external component, it has an internal component also.
Different context, but I'll assist your lordships on that.
By and by, in your turn, you can explain
Yes,
that
yes.
that line of. We are really on the list of dates. You can go ahead. Yes.
25th 11/1949, Yuvraj Karan Singh issued a proclamation for the state of Jammu and Kashmir. I have given the pagination, by which he declared and directed that Constitution of India, shortly to be adopted by the Constituent Assembly of India, govern the constitutional relationship between the state and the contemplated Union of India, and shall be enforced in the state by him, his heirs and successors, in accordance with the tenor of its provisions. The same proclamation is worth quoting in full. Whereas with the inauguration of the new constitution for the whole of India, now being framed by the Constituent Assembly of India, the Government of India Act 1935, which now governs the constitutional relationship between this state and the Dominion of India, will stand repealed. Your Lordships may kindly recall the instrument of accession was under Government of India Act and subsequently Independence Act. And whereas in the best interest of this state, which is closely linked with the rest of India by a community of interest in the economic, political and other fields, it is desirable that the constitutional relationship established between this state and the Dominion of India should be continued as between this state and the contemplated Union of India, and the Constitution of India as drafted by the Constituent Assembly of India, which includes duly appointed representatives of this state, provides a suitable basis for doing so. I now hereby declare and direct that Constitution of India, shortly to be adopted by the Constituent Assembly of India, shall, but please mark this, this is where, my lord, they are highlighting and I will have to meet with, insofar as it is applicable to the state of Jammu and Kashmir, govern the constitutional relationship between this state and the contemplated Union of India, and shall be enforced in this state by me, my heirs and successors, in accordance with the tenor of its provisions. That the provisions of the said constitution shall, as from the date of its commencement, supersede and abrogate all other constitutional provisions inconsistent therewith, which are at present in force. This is beyond any instrument of accession or merger. This is accepting supremacy of our constitution and surrendering the sovereignty to the constitution, where the sovereign is we, the people of India. No.
Of course, when he made this proclamation on 25th of November 1949, this is on the same day as Dr. Ambedkar's last address to the Constituent Assembly, the famous address to the Constituent Assembly. So by this point of time, the entirety of the Constitution had been formulated.
Including 370.
Right? Including 370.
And Article 1.
Therefore, when he makes this proclamation, he makes this proclamation in the light of 370, which also is before him.
Correct.
Right? There can't be any doubt about that.
There cannot be any doubt. I bow down. And he is also very clear that what he is doing, at what stage and under what statute, what constitutional mechanism which is temporarily provided. The said proclamation is not only beyond the instrument of accession, your lordships can skip that, I have orally said. Two, the preamble to this proclamation shows that it was based on the conviction that the best interest of the state required that the constitutional relationship established between the state and to Dominion of India should be continued as between the state and the contemplated Union of India. And it refers to the fact that the Constituent Assembly, which had formed the Constitution of India, included the duly appointed representatives of the state, and that the state constitution provided a suitable basis to continue the constitutional relationship between the state and the contemplated Union of India. At this juncture, the Constituent Assembly of Jammu and Kashmir was not formed. However, it is important to note that the princely state, through its ruler who had the authority to surrender the sovereignty of Jammu and Kashmir to the Union of India and made it specifically enforceable in the state, including Article 1 thereof, could never have thereafter formed a constituent assembly for his state, which would be a plenary constituent assembly, which can create a document having the sanctity and sovereignty of the constitution of a nation in which the state merged. It was merely an act providing for internal governance of the state, which was an integral part of the sovereign, that is Indian dominion. But my respectful submission is that Constituent Assembly of Jammu and Kashmir, which formed subsequently, was not a plenary Constituent Assembly the way we had our Constituent Assembly, because by that time the sovereignty had already merged. There cannot be two constitutions. There cannot, and therefore, my lord, I am saying that the sanctity of that document, which we call Constitution, is nothing more than an act of legislation, and I'll substantiate that. Note 4. This furthers the point that the words Constituent Assembly in Article 370, sub-article 3, can be read only as Legislative Assembly, even without the aid of Article 367. Apart from this,
Solicitor, this will require a little clarification.
Yes, yes, but
This
when I
will
come-
require a little clarification. At this stage, we are not saying anything because when we talk about Article 370, including the explanation which is added, which
as
is,
separate submissions.
that will require clarification.
But I'm conscious this is not the best point where I can justify the substitution.
We are not stopping you at this stage because you're going on facts.
This is not the best point on which, my lord, I would be able to justify substitution of a defunct Constituent Assembly with legislature. I'm not, my lord, joining issue with it. I have other set of submissions on that. At this stage, my lord, this is the perception, my lord, which I am presenting for your lordship's consideration. Now, my lord, kindly come to 26/11/49. The Constitution of India is adopted. But the rest I can.
So, Mr. Solicitor, what we, as apropos what fell from Brother Justice Sanjeev Khanna, we are not engaging in a dialogue with you on any of these notes right now, because we take it that you will be arguing these aspects independently later on.
I just want to draw.
So, right now we'll run through the list of dates with you,
Correct,
so we have a broad drift of your
Correct.
analysis.
I just want to point out
But
broadly.
we take it that you're going to take up each one of these strands later and argue them independently.
have-
Then we can, so instead of asking you any of our doubts right now, we'll
Correct.
reserve it to when you go into the themes themselves. Right now, we can just run through the list of dates.
What I
Isn't it
intend,
better?
Lord, assisting your lordships, the way is this, my lord. After this, my lord, I'll show how the Constitution, how 370 worked till 2018, and some of the things are really shocking. And my lord, I want your lordships, my lord, to know about, because practically, two constitutional organs, state government and the president, in consultation with each other, can amend any part of the constitution the way they want and apply it to Jammu and Kashmir. For example, I'll elaborate on this. Please mark this. The preamble of Indian Constitution was made applicable to Jammu and Kashmir by way of a constitution order under Article 371B. In 1954. Thereafter, in 42nd and 44th Amendment, the word socialist and secular came to be added. That was not made applicable till 5th of August 2019. Jammu and Kashmir constitution was not having either the term socialist or secular. And I will show my lord, the devastating effect it would have, my lord, if this constitution, which according to me is nothing more than a legislature, would not have been repealed the way, my lord, we have done. I'll explain the procedure which we have followed. I must satisfy your lordship's conscience. My lord, your lordships have very rightly flagged that ends may not justify the means, but I'll justify the means also. They are constitutionally permissible means.
Eventually, when you argue that this is really not a constituent assembly but a legislative assembly in its original form, you'll have to answer how this squares up with clause 2 of Article 370, which specifically says the constituent assembly formed for the purpose of framing the constitution of that state.
Correct. I have to answer.
That is because there's a textual answer which may militate against your line of approach on that.
Yes.
Anyway, we'll discuss that later on because.
Kindly come to my lord, page 47. So it's, can I, my lord, this is a new point, my lord. Now, first constitution order comes, my lord, I
think you can continue on
Monday.
Monday morning.